In this video, we are going to discuss section 420 of IPC, which is now have become 318 subsection 4. So 318 provides cheating there in Bharatiya Nyaya Sanhita 2023, and its subsection 4 is the copy paste of section 420 of IPC. So now 420 has been 420, 418, 415, and all the provisions relating to cheating are now under section 318 of BNS. So there are four subsections in BNS under which all these provisions of cheating are integrated into a single provision. So we will discuss cheating, and whenever cheating is coupled with the delivery of property, and so it becomes section 420 and now 318 subsection 4 of BNSS. So cheating is provided under section 318, and there are four subsections under 318, as well as in IPC it is section 415, and 420 is cheating when it is with the inducement to deliver property. So whenever there is a inducement to deliver a property and cheating is there with such ingredients of inducement to deliver property, then it is section 420. So a cheating barely can be without delivery of property as well, can be committed even when the inducement to deliver property is not there. But for commission of category of offence provided under section 420 of IPC as well as 318 of subsection 4, the provision is all about whenever the cheating is committed, the cheating is obviously must be there, and that should be together with the dishonest inducement to deliver the property. So then only 318 subsection 4 and 420 of IPC is attracted. So here in this video we are going to discuss cheating as well as the ingredients of cheating, and when subsection 4 of 318 and 420 of IPC is attracted. So 420 IPC and 318 subsection 4 of BNS. So this is a provision which is a copy paste of 420. So 420 IPC was this, and the same provision has been added under 318 subsection 4. So provision is similar, and the provision starts with whoever cheats. So before reading out this provision, we must know what is cheating. So whoever cheats means cheating must be there under 420, and cheating provided under 415 of IPC, and here subsection 1 of 318. So we must first learn what is cheating. So cheating says whoever by deceiving any person fraudulently or dishonestly. So ingredient 2 or can be 3, either of it. Fraudulently or dishonestly induces the person so deceived. Ingredient number 4 induces the person so deceived to deliver any property. Deceived to deliver any property to any person. So it can be to a deception to deliver any property. So whoever by deceiving any person, somebody deceives any person, fraudulently or dishonestly induces the person. After deceiving, he fraudulently or dishonestly induces the person who is deceived to deliver any property to any person. Number 1, after deception, after fraud, dishonesty and inducement, he causes that person to deliver any property. After clearing the intention, what he is doing to make it cheating. First, to deliver any property to any person, or to consent that any person shall retain any property, or intentionally induces the person so deceived to do or omit to do anything which he would not do or omit if he was not so deceived. And upon that act or omission, he is likely to cause damage or harm to that person in body, mind, reputation, property, and this is called cheating. So once again, understanding the ingredients: whoever by deceiving any person fraudulently or dishonestly induces the person. So deception is mens rea, fraudulently and dishonestly inducing the person is mens rea, and then comes the actus reus. What he is doing, he is deceiving the person, right? And the person who is deceived, he causes that person to deliver the property to that person, or to consent that any other person shall retain the property. So this is what he is doing. Or what he can do, he intentionally induces the person to induce a person so deceived to do or omit to do anything which he would not do or omit if he were not so deceived. So causing any person to do something or not to do something just because of that deception, that inducement created by the person who's committing such offense, and what he's wanting, what effect he is wanting. So effect of the act, as above stated, effect is the which act or omission causes or likely to cause damage or harm. This is damage or harm to that person in body, mind, reputation, property. So the effect, the damage or harm can be in body, mind, reputation, or property. So this is called cheating. Now there is this explanation provided which says a dishonest concealment of the facts is a deception within the meaning of this section. So somebody who's dishonestly concealing something is also can be deception. Now there are a number of illustrations provided under section 315 of IPC, and illustration number 1 says A, by falsely pretending to be in the civil services, intentionally deceives Z and thus dishonestly induces Z to let him have on credit goods for which he does not mean to pay. So A cheats. So here A, by falsely pretending to be a civil servant and intentionally deceives Z that he is a civil servant, and by doing so he let him have some goods on credit for which he does not mean to pay. So he is not intending to pay for some goods he took on credit from Z, induces him and deceived him to he is misrepresenting, he is falsely pretending to be a civil servant and then deceives Z and induce him on the basis of this information that he is a civil servant. He induces Z to give some goods on credit, and he does not mean to pay for the same. So this is cheating, and all the ingredients of cheating are met. Interesting thing is that this illustration also falls under section 420 of IPC, which is subsection 4 of 318 also. So as delivery of property is there, goods is considered also a property, which we will discuss with the provision there. So whenever there is a delivery of property with cheating, the gravity of offense become little more serious, and the punishment is the only difference between cheating in 415 and 420 of IPC, as well as section 318 subsection 1 and 4, is that the gravity of offense becomes little more serious in the latter case, where the inducement to deliver property is there with cheating. Now illustration B says A, by putting a counterfeit mark on an article, intentionally deceives Z into a belief that this article was made by a certain celebrated manufacturer, and thus dishonestly induces Z to buy and pay for the article. A cheats. So obviously there is a, whenever cheating is there, some wrong information or false information is there about the person, about the thing. There is a deception. Deception means that you are wanting somebody to believe in something which is not right. So in simple terms, you can, whenever there is a deception, there is a false information. And so here a counterfeit mark on an article has been added. Then intentionally another person is deceived to believe that this article was made by certain brand or authority, or here in this case celebrated manufacturer. So thus on such a belief dishonestly induces Z to buy and then pay for the article. So here is cheating has been committed. Illustration C says A, by exhibiting to Z a false sample of an article, again false and sample of an article, intentionally deceives Z into believing that the article corresponds with the sample, and thereby dishonestly induces Z to buy and pay for the article. So here the thing is that if I show you a mobile phone having some qualities and features, and then ask you to buy the same, offer you to buy the same, and if that article, the sample which I am showing to you is a packed article, if you want to buy a new one, there is a packed article, and you buy that article, when that article has been later checked, it is found out that the article was not same as the sample shown to you when you bought it. So this is obviously cheating, because I am showing somebody a sample of something which is having some qualities, but whenever the packed article, the article which was purchased was not having the same qualities, the same features as the sample was shown at the time of purchase. So this is cheating. Now illustration D says A, by tendering in payment for an article a bill on a house with which A keeps no money, and by which A expects that the bill will be dishonored, and intentionally deceives Z and thereby dishonestly induces Z to deliver that article, intending not to pay for it. So this illustration is all about the time when the bill of exchange used to be there, and when people used to buy some article, they used to draw bill of exchange. You can understand this example like this, that I buy something from you and I deliver a check, I draw a check to you, and I know that when you deposit the check in bank, that shall be definitely dishonored, because I am not having any balance in the bank to honor that check. So this is the same example when I am having some deposits with somebody at some house, and I draw a bill of exchange on that account, and I buy something from you, I draw a bill of exchange, and when you take that bill of exchange to deposit to show the person, he denies that we are not having any amount, any deposit of that person who has drawn that check, the bill of exchange to you. So this the consequence would be definitely a dishonor. And if I am knowing this with certainty that there is no amount remain with that person, that house, or in case of check in bank, then I know that this check or bill of exchange will definitely be dishonored. So in this situation, when I am knowing this fact, this is a cheating, that can be definitely dishonor of check, or 138 covers of NIA, dishonor of checks. There is no provision for bill of exchange, which is making it an offense under like 138 of NIA, but it is definitely cheating if the person is knowing this fact that this will definitely be dishonored. So this is illustration D. Now example E says, A by placing as diamonds articles which he knows are not diamonds, and intentionally deceives Z and thereby dishonestly induces Z to lend money. So again the same example, that diamonds which he was placing were not actually diamonds, but he gave the false information that the diamonds are original, and then intentionally deceives Z to lend money on behalf of those diamonds. So this is again cheating. Then F says A intentionally deceives Z into a belief that A means to repay any money that Z may lend to him, and thereby dishonestly induces Z to lend him money, and A not intending to repay it. So again the somebody having this intention that he's taking a loan, and then he intends not to repay the same, this is cheating. Then G says A intentionally deceives Z into a belief that A means to deliver Z a certain quantity of indigo plant which he does not intend to deliver, and thereby dishonestly induces Z to advance money upon the faith of such delivery. A cheats. But the first half of the example is very clear that it is cheating, that he intentionally deceives Z that he wishes to deliver some quantity of indigo which he actually doesn't intend to deliver. So this is cheating. But the second part of the illustration says that if A at the time of obtaining the money intends to deliver the indigo plant and afterwards break his contract and does not deliver it, he does not cheat. So this is to be understood that the Honorable Supreme Court and so many high courts have made it clear that cheating is there only when there is a intention of inducement, fraudulent or dishonest intention to deceive and induce somebody, and there these elements, the mens rea is present at the very inception of any transaction. So here, if A at the time of obtaining the money intends to deliver the indigo plant, he was actually intending to deliver it, but afterwards he break the contract. He afterwards found out that he is not able to deliver the same. There may be some reasons, but he, after making the at the time of making the agreement, he wished the some articles here in the illustration, the indigo plants, to delivered, and on that agreement he takes money, and then afterwards he break the contract saying that no, we are not having the indigo plants. So this is not cheating, this is a breach of contract. So the right remedy for these cases would be to file a civil suit. This is how so many petitions are filed before high courts under section 482 against the FIRs under section 420. The reason is that in many cases the cases lack the ingredients of cheating, that the ingredients of cheating must be at the very beginning of the transaction, and they cannot, if the element of cheating is occurring in midway or after the transaction has taken place, and somebody is, for like in this present illustration, that he is not able to deliver something which he promised, in those cases it cannot be cheating. So there the what happens in 482 in such cases that the Honorable High Courts tend to quash the FIRs. So this illustration is something which has been interpreted by the Honorable High Court, that the maker of this provision did not intend to make those failure in the breach of contracts to become an offence under section 420. So that's why this illustration was expressly included in this provision, that whenever there is a failure in complying or following some contract, the agreement, and the contract when took place, the party was intending to comply the conditions of the contract. In those cases, it is a breach of contract, not. But at the very inception, that somebody was taking money, but he never had those articles to be delivered, or had no intention to deliver, then in those cases it is 420. So I hope this illustration makes you very much clear this clear difference, that the breach of contract and the cheating has two different consequences, and whenever there is a breach of contract, there may be a confusion whether it can be cheating or not. So it should be seen such that the elements of cheating must be present at the very inception of the agreement transaction. So now come to illustration H, and A intentionally deceives Z into a belief that A has performed A's part of a contract made with Z, which he has not performed, and thereby dishonestly induces Z to pay money. A cheats. So here the illustration says that A says that I have performed my part of contract, but he is actually not performed, and he sought some benefit from the other party of the contract on this false belief of his performance. So this is also cheating, when because the elements of cheating are there. The intention is very clear that he has not performed, but he is making the other party to believe that he has performed. So illustration I says A sells and conveys an estate to B, knowing that in consequence of such sale he has no right to the property, sells or mortgages the same to Z without disclosing the fact of the previous sale, and conveys to B and receives the purchase or mortgage money from Z. A cheats. So A sells and conveys an estate to B, knowing that actually he is selling that property, but he has no right to that property, and then again sells or mortgage the same to Z. So first he conveys to B, and then knowingly sells or mortgages again to another person who is Z, so without disclosing the previous sale. So even he was earlier not entitled to sell the same, because he is not having any right, and then selling it to, conveying it to B, then again sale or mortgages to Z. So it has been, actually the fraud has been committed, the cheating has been committed with two people here. So this is clearly a cheating case. So I hope these illustrations given under section 415 of IPC and 318 of BNS helped you in understanding the practical cases of cheating. So the nature of offence is, it is a cognizable offence and it is non-bailable. I am talking about offence under section 318 subsection 4, which is with inducement to deliver property. Cheating and then inducement to deliver the property is a separate offence under section 318 subsection 4, and which is 420 of IPC. So you must understand that this offence is cognizable and non-bailable, whereas the cheating under subsection 1, the cheating, only cheating, is non-cognizable and bailable. Also it is triable by JMFC and compoundable by the person cheated with permission of the court. So in compounding the same, the permission of the court, under section 320 of CRPC it was a provision for composition, but now under section 359 of BNSS, Bharatiya Nagarik Suraksha Sanhita, 359 provides for the compounding of cheating there, but with the permission of the court. So now after understanding what is cheating, here we are going to discuss specifically section 420 of IPC, which has now become 318 subsection 4. So it says whoever cheats. So as we have discussed cheating, those ingredients of cheating must always be there in these offences of inducement of property with cheating. So whoever cheats and thereby dishonestly induces the person to deliver, deceive to deliver any property to any person, or to make, alter or destroy the whole or any part of the valuable security, or anything which is signed or sealed and which is capable of being converted into a valuable security. So here with cheating there must be dishonest inducement to deliver property to any person, or make, alter or destroy whole or any part of valuable security. So valuable security or any property. Now property means every kind of property, that includes movable property, and that property must have some value. So in those cases it is falling under section 420 and 318 subsection 4. And anything which is signed or sealed and which is capable of being converted into valuable security. So anything which has now having no legal value, but which can which is capable of being converted into a valuable security, and this offence is punished with imprisonment to 7 years and also fine. Cases falling under 318 subsection 4, which was known as 420 IPC. Now simply cheating is punishable with 3 years. Cheating subsection 1 of 318 is cheating, 3 years of punishment is there, but in cases which falls under 318 subsection 4, it is punishable with 7 years and also be liable to fine. So if you see the subsection 1, 318 and 415 of IPC, whichever you can understand that there in the provision, delivery of property is also an ingredient there. But here why they have made this separate provision is just to differentiate the gravity between both of them. Here if there is a delivery of property, certainly there is a delivery of property, then it will fall under this subsection, or if in IPC then 420, and this differentiation is just to differentiate the gravity, and that's why here the punishment is 7 years, but in simply cheating it is 3 years. So the difference of punishment is just because there is a difference in gravity. The essential ingredients of 420 of IPC. First ingredient is cheating must be there. So I could not add here. I forgot to add that cheating must always be there. So after cheating, there must be deception. There must be an act of deception or fraudulent representation from the inception of the transaction. So from the very inception of transaction, there must be deception, and this means that accused must have misled the victim from the very beginning of interaction. Then dishonest inducement. The accused must have induced the victim to deliver property through dishonest means. This involves a clear intention to deceive the victim into parting with their property. Then essentially there must be delivery of property. The aggrieved have delivered property after the deception, and this delivery must be direct, connected with the dishonest inducement by the accused. The term property includes tangible properties like money, goods, as well as intangible properties like intellectual property rights. So here the property includes tangible and intangible both kinds of property, and it includes money and any goods which has some value, or even the valuable securities as they are provided there in the provision. So delivery of property is an essential ingredient of 420. And then resulting loss. That act of cheating must cause wrongful loss to the aggrieved person and gain to the accused. Now in those cases where the dishonor of check can also fall under the category of cheating under section 420 or 318 of BNS. So here I have put this example that drawer of check knowingly issues check on a closed account or account which doesn't exist, or even on account having insufficient funds, and this fact was known to the drawer of check, and having the knowledge of the fact that the check will certainly be dishonored, the same has been issued in favor of some person. In those cases, in these circumstances, it is 420 IPC 318 subsection 4 of BNS. So this is cheating which falls under the category of this offence. Although definitely the dishonor of check under section 138 of NIA, that case can also be instituted and can be prosecuted separately, but it can also come under the category of offence of cheating. So this must be made clear. Every dishonor of check cannot be cheating, where the element of deception, intentionally drawing a check on a closed account, or the drawer knows it that this is definitely going to be dishonored, as we have discussed also in the illustration given under section 318 subsection 1 oblique 415 of IPC and BNS. So in those in that illustration we have made it clear that intention matters. When the person is drawing the check, he was knowing the fact that it is certainly going to be dishonored. In those cases it is cheating. Now this was a landmark judgment with regard to section 420 IPC prosecution, and here Hridaya Ranjan Prasad Verma versus State of Bihar. It was a judgment of 2000, and this is a citation. Issue was whether when the breach of trust and cheating is there. So in determining the question, it has to be kept in mind that distinction between mere breach of contract and the offense of cheating is fine one. It depends upon the intention of the accused at the time of inducement, which may be judged by his subsequent conduct. But for this subsequent conduct, it is not the sole test. Mere breach of contract cannot give rise to criminal prosecution for cheating unless fraudulent or dishonest intention is shown right at the beginning of the transaction, and that is the time when the offense has been committed. So therefore, the intention is the gist of the offense. To hold a person guilty of cheating, it is necessary to show that he had a fraudulent or dishonest intention. There is also a provision I mentioned earlier, that cheating with knowledge that the wrongful loss may ensue to a person whose interest the offender is bound to protect. So whoever cheats with the knowledge that he is likely thereby to cause loss to a person whose interest in the transaction which the cheating relates, he was bound either by law or by legal contract to protect, shall be punished with imprisonment of either description, which may extend to 5 years. Provision was there under section 418 of IPC and subsection 3 of 318, and punishment in IPC was just 3 years, but in BNS it is 5 years now. So this was a separate provision with regard to persons whose interest the offender is bound to protect, and if he commits cheating, then 5 years of punishment is provided. Now there is another provision whenever there is a cheating by personation, which means that if a person cheats pretending to be some other person, or by knowingly substituting one person for another, or representing that he or any other person is a person other than he or such other person really is. So whenever there is a cheating, the false information about the individuality, any person's identity, then in those cases there is a separate charge of section 319 of BNS, and this is called cheating by personation. So here in more detail, when a person pretends to be some other person who or knowing he is substituting one person for another, or he is representing that he or any person is a person other than he or such other person really is. So for example, here that A cheats by pretending to be a certain rich banker of same name. A cheats by personation, and then A cheats by pretending to be B, a person who is deceased. A cheats by personation. So A is saying that he is some individual, but actually that individual is no more. Here in example 1, he is a rich banker of the same name. Somebody having a name, for example Pradeep, but another individual naming Pradeep is there who is a banker, and here he is representing himself to be substituting himself to be Pradeep, a rich banker. Here he is committing cheating by personation. So this is a separate offense, and punishment for cheating by personation is 5 years or fine or both, and it is a cognizable but bailable offense and triable by any magistrate. Now to differentiate between cheating and criminal breach of trust, both these offences are different in IPC. So in cheating, primarily involves deception and inducing a person to part with property. Here involves a violation of trust regarding property that has already been entrusted to the accused. Cheating primarily involves deception, inducing a person to part with property. Here the person, it involves violation of trust regarding property that has already been entrusted to accused. So the in breach of trust, the property is already been entrusted by the owner of the property, but there is a breach of trust at later stage done by the person whom this property was entrusted. So it is a clear difference. Then the intent to deceive is from the very outset. Here intent to deceive may be there afterwards when the property has been entrusted. So deception after entrustment is there, then it is a breach of trust, but in cases where it is from the very beginning of the transaction, it is cheating. The property need not necessarily be in possession of the accused at the time of the deception, but here the property is already with the person who is accused of the breach of trust. In cases of breach of trust, offense of breach of trust, it is non-cognizable and bailable, it is cognizable and bailable. Here I am talking about barely cheating, not cheating with inducement to deliver property. So because inducement to deliver property is also a cognizable and non-bailable offense. Here it is cognizable but bailable. Both these are bailable, but cheating is non-cognizable, but breach of trust is cognizable. The punishment for cheating is 3 years or fine or both, but for breach of trust it is 5 years. Earlier it was also 3 years, but in IPC, but it has been increased to 5 years. So thank you so much for watching. I hope I have done it well. If you liked it, please subscribe the channel and like the video. Thank you.